is that the charges were defective and upon careful scrutiny were filed against the promptings of plain common sense. In the case of Republic versus Collins Dowda and others, for instance, the first accused was charged with misapplying public funds to the tune of 200 million United States of American dollars. In laying the charges, the prosecution failed and or neglected to take account of the basic fact that it was part of that 200 million US dollars that was used to construct the houses at Shadley. In other words, the value of that built environment is, in my considered opinion, a key determinant of how much of the total sum was allegedly misapplied by the Honorable Collins Dowda. Discounting the value of the built environment renders those charges, in my considered opinion, defective. The prosecution in this case also failed and or neglected to take account of payments that were made by other ministers who took office after the Honorable Collins Dowda. For instance, the Honorable Atachia, as Minister of Works and Housing, approved a payment to the tune of 5 million United States of American dollars in 2017 that ought to have been considered in determining the value of state funds that the Honorable Collins Dowda had misapplied. But that wasn't done. And note, ladies and gentlemen of the media, that the Honorable Atachia was never charged, even though the Honorable Collins Dowda was charged subsequent to the actions of the Honorable Atachia. So I leave that to your own considered judgment as to why that happened. Now, in criminal law, an accused is entitled to know with precision the crime that he has committed and the burden that he must discharge in order to prove his innocence. This is basic criminal jurisprudence, and the charges in this case, and the other in terms of the cases affecting the other accused persons, fail to meet the standard of precision required to put an accused person on notice of his criminal liability. Ladies and gentlemen, the third reason why I dropped the charges in some of the cases was that the evidence adduced so far fell significantly short of what was required to convict the accused persons, and yet the state pressed on with the prosecutions. I consider that to be a total waste of state resources. As noted by Command GSC in Afoko and Attorney General, that is the case that I cited earlier, the prosecution may enter a nolle prosequi in situations where, upon review of the proceedings, the Attorney General detects fatal flaws in the case which may lead to the acquittal of an accused person. In other words, a nolle prosequi may be entered to avoid possible verdict against the prosecution. My review of some of the cases certainly revealed fatal flaws in the case of the prosecution. A few examples are in order. In two of the banking trials still ongoing, I took the decision to withdraw the charges against Mr. Johnson by the erudite judgment of the Court of Appeal, which ruled that the trial court erred in calling upon the accused persons to mount their defense. When the then Attorney General, the Honorable Godfrey Yebo Adame, vowed to file an appeal and actually went ahead to do so, I took the view that it was done to save face and that there was no scintilla of merit to his appeal. Indeed, the appeal was, to say the least, grossly incompetent. My involvement in the case of Republic versus Ofosu-Ampofo and another is a matter of public record. At the initial stages of the trial, I was on record as counsel with the Venerable Tony Lita and my former boss, the Honorable Marietta Brew. It was our position as a team that the charges against the Honorable Ofosu-Ampofo were trumped-up charges and motivated purely by politics. I still stand by that view. Ethically, a prosecutor should and must have the courage of his conviction